And thank you very much for joining us here on PM Express. I'm pretty sure you have followed the controversy that has erupted, pitching the OSP family against Ken Ofori-Atta again. And this fight is now being played on the turf of Interpol. Both parties have been making strong arguments to Interpol. One side arguing you need to pull down the red notice. The other side arguing do not pull down the red notice. In fact, in the last few months, we are now learning today that Ken Ofori-Atta assenting an argument, making the case why he shouldn't be there. The OSP was asked to respond. They did respond. Then Ken Ofori-Atta fired back with another response. The OSP has been asked to respond again. Very interesting indeed. And there's a lot to learn tonight about this drama that is unfolding. Bottom line, Ken Ofori-Atta is no longer, at least, the public-facing part of the Interpol red notice that we have seen and followed over the months. He is no longer there. The OSP says that has been redacted, but it's not there. And the reasons we're learning today because Ofori-Atta wrote and argued. And I'll give you the circumstances under which the Interpol may consider the redaction of a red notice. But fascinating indeed. And it comes in the context of what we've seen recently, with the OSP finally going to court and charging the man, not only him, but a few others too, including Ernest Dako Akori and 5 others. And some of them very powerful people in society in the past. Reverend Dr. Amishade Owusu is among them. And this was just filed in the last 24 hours. And so that case is now before a court of competent jurisdiction. And it's traveled since February 14, 2017, when SML was incorporated, all the way to October 2025, when the presidency terminated the contracts. The OSP has been looking closely into it, and it's come up with 78 counts in total. It's jaw-dropping when I saw it, but yes, you're not getting this right. Wrong. It's 78 counts in total. And it's going to be a fascinating case indeed before the court of competent jurisdiction, especially when you try somebody in absentia. And then we talk about the key charges, just summarizing it for you. Multiple procurement breaches, causing financial loss to the state. It had to be in there somewhere. Using public office for profit is another one that has been put forward. The particulars of offense are equally very fascinating. They lack technical expertise, is what the OSP claims. The full service was not performed. No PPA or parliamentary approval was there, and egregious procurement breaches, the OSP says. And then, of course, automatic payments with no verification. So the OSP, as far as it's concerned, has what it takes to nail this, right? But as you know, it's never straightforward. The individuals are innocent of the proving otherwise. And to sum it up, the OSP says there was no genuine need for this contract. So this was created. Some people allegedly looted, and that loot was shared, to quote a certain judge. So that's where we are. But then when you put the sum together, involved, 1.4 billion. That's alleged financial loss to the state. 1.4 billion cedis. Jaw-dropping indeed. But the OSP is giving us a bit more now. Now that he's gone to court, we know a bit more. According to the court papers that we've seen, there was an audit that was done that pulled the figure of 506.7 million, right, in terms of the audit and price verifications. And then you come to the downstream sector, which again they were monitoring, and they went away at, I believe, with what the documents say, with 929.5 million. So lots of money at stake here. If you put it all together, what gives you the billion cedis, and the upstream SML contract alone was valued at 2.7 billion. These are jaw-dropping numbers indeed. And then we go to the website, because the whole idea was that Ken Ofori-Atta was the kingpin, the mastermind of all this, because he was the finance minister. He was the guy with the most resources, most influence to get this to happen. This is the website of Interpol. And when the red notice was filed, remember the wife spoke to me on Newsnight, and clearly this had been bothering him because of the reputational damage it comes with. You can't even move freely because you don't know what whether you're going to be, Interpol red notice is red notice. It's not an arrest warrant, but if you found him, it could have significant consequences for him. And so he was there for a while. And then we checked today and we realized that no longer there. And then the OSP itself came forward with the details why it wasn't there. And then we learned that Ken Ofori-Atta had initiated a process to remove it. Now, what fascinated us is the OSP, the Interpol, had the governing principles around the criteria for posting a red notice and removing a red notice, if you like, redacting it. And one of the things that we saw in terms of the criteria for removing it, pulling it down, or redacting it, interesting. If the individual in question, as in this case, Ken Ofori-Atta, submits a request to Interpol's Commission for Control. So Ken Ofori-Atta, as we know, did submit the request, and they must argue. This is a process for redacting the redaction of Interpol red notice. They must have argued in there why this request should be heeded by Interpol. So that's what happened. So indeed, the Interpol itself lays out a procedure for redacting a red notice, and Ken Ofori-Atta had triggered it. He himself and his lawyers, they did a submission, and then the decision is expected to be taken, a firm decision, within 9 months, is what Interpol tells us. But this one was the one that interested me quite significantly. The Commission may block the alert pending full decision. It is discretionary. It is discretionary. They may do so, but it is entirely discretionary. When I say now, I'll read the entire wording for you to see. It is discretionary. And that discretion must be exercised not capriciously, but must be fairly applied. So it begs the question, is it possible that the Interpol may have seen the Ken Ofori-Atta's request and may have found in them some merit, and so they redacted it? I don't know, but it's a question. The OSP is very firm on the matter that this is not a removal from the website and the red notice is gone. It is just a redaction because they are waiting for that decision. It's going to take 9 months for this to happen. When that decision is taken, OSP is very confident that it will be put back. So, and they're waiting. They have a 21st of November deadline to submit the latest rebuttal to Ken Ofori-Atta's love letter to Interpol. So that we're waiting to see what happens there. And then there are a variety of other considerations that the Interpol will look into in deciding whether to put it there in the first place. So that, for me, is an interesting matter. But remember, this conversation is just not about Ken Ofori-Atta and this extradition and red notice, because the extradition concern itself is there. On the back of this contemplation at Interpol, what to do with his request for removal of the red notice, how does that affect the country's process to extradite him to Ghana? My lawyer friends will join me on PM Express shortly to ask that question. Does it affect it in any way? Because remember, the Attorney General has begun the process to have him extradited. But now that the red notice itself is now a subject of contention and it has been redacted, how does that affect that process? We'll ask that question when we sit for a conversation here on PM Express. And you notice about the offenses of an administrative nature that they consider. It's quite a bit. My guests are joining me for a conversation tonight. Stay, a lot to learn here on PM Express. And thanks for staying with us here on PM Express. It's always brought to you by Centric Science. It is strong, it is tough, Academic Times, and Pepsodent Cavity Fighter. My guest joining me for a conversation tonight is Martin Kpebu. He is a lawyer. He himself has been before the OSP today. I'll ask him how that exercise went. Also joining me for a conversation is Kweku Ansansare, who will join me for a conversation pretty shortly. Also joining me is Professor Kojo Piejutia, a professor of international law, also joins us now. Nane J. Bafwewa is MP for Menchia South. I'm grateful that he's here because Parliament has been sitting till very, very late as they debated the budget, and he himself has been on his feet in Parliament doing just that. And so I'm grateful that he can join me. And because we'll talk quite substantially about the OSP and his battles with Ken Ofori-Atta on the back of the Interpol red notice redaction. Let me start with you, Martin. You yourself had your own battles with the OSP recently. Today, you were before the OSP.
Yes, absolutely.
You were invited formally by him.
Yes.
Okay, what happened?
Oh, so to be clear, I'm not being investigated for any offense, right, at all. But rather, I'd made some comments, and which he says I should come and clarify. Putting it bluntly means they want some evidence to back that, to help the corruption fight, right? Yeah, so what are those comments I made? Number one, and that's the most salient, and that's something that by now the special prosecutor himself, the SP, should have resigned. That is the fact that he finally came to confess, right, I think on the 5th of November, that before Ofori-Atta traveled, he, Kisi Ejabin, intercepted the letter Ofori-Atta wrote to both the incoming chief of staff and the outgoing one. He said he intercepted the letter, then he ran to NIB, didn't get help, ran to National Security, didn't get help, and ran to Immigration and didn't get help. This is a big indictment on these institutions, right? We'll come to that. That's a separate argument. But worst of all, it didn't occur to him, the man who had done Ankwa Numa press conference, it didn't occur to him that he should blow the whistle. That's inform the people of Ghana through a presser. Do a press conference. Hey, people of Ghana, I have clear evidence of Ofori-Atta is about to travel out of Ghana. I've gone to these institutions. They are not helping me, so come help. You know how many people would have taken steps, besiege the airport to prevent Ofori-Atta from traveling? And even at that time, look, ORA, I was part of the ORA team. We're working. We had security couples, Kofi Boati is on the ORA team, and there were people back room, people who were supporting.
SML was part of those incidents that you investigated as part of ORA, right?
The receipt, yeah, receipts of we're basically collecting,
which is also what the
complaints.
OSP was looking.
Yeah, so but the key things are, so he says he got the letter. Ofori-Atta says I'm traveling. Well, for medical, let's leave out the reasons. But the main thing is that he says he's going out of Ghana. Kisi Ejabin had the letter and sat on the letter. Come on, look.
But you yourself have said that's not what he did. He tried to get the state agencies to intervene to help him secure him. And they didn't. He says that didn't happen.
Oh,
so he didn't sit on it.
So far, I can tell you, Evans, an authority that I spoke to somebody at NIB, that person was in charge at the time. He says he has never received anything from Kisi Ejabin, meaning that now Kisi Ejabin must produce evidence. What did he take to the NIB man? Right, for now, I just want to leave out names. As now we are advocating for full investigations into this matter, we'll call the NIB man. Kisi should come and show what did you take to the NIB boss at the time. What evidence did you take to him? In any event, your own law, Section 28, says you have police powers. So what is it? What was so difficult about arresting Ofori-Atta? It says officers to exercise powers of police. So I'm reading the Office of Special.
At the time, they could have only held him for 48 hours.
But then you go to court. Yeah, you hold the person.
They didn't have enough to go to court at the time, obviously.
Excellent.
It's taking him this long to go to.
You know what? I don't want to argue about
78.
That. Yes, perfect.
Charges.
Yes, granted. He didn't have enough to arrest him. Then why did he say so in the interview? You see him. He says he got wind of it, he intercepted it, and went here, trying to stop it. If you say you don't have enough on him, why are you stopping him? So you see the problem. If you don't have anything on him, why would you be going to, allegedly, because like I've told you, the BNI man is denied. So we have to push this into a commission of inquiry. Kisi has to lose his office over this. Remember Watergate? Nixon, president, lost his office. You can't sit. Our chief prosecutor, Evans, listen, it's not a rant. We are talking serious constitutional law. It's not a rant, except that because it's so shameful, this is a big embarrassment, yet we are not waking up to it. That's why I think I have to ratchet up the conversation, increase my voice. I'm not agitated, but I mean, I want Ghanaians to look, when you look at the, what do you call it, our constitution, all right? You see sovereignty in the preamble. You go to Article 1, Clause 1. The sovereignty of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers of government are to be exercised in the manner and within the limits laid down in this constitution. You go to Article 35, it's there. 125 is there. So where allegedly, because those institutions are yet to respond, if some institutions are allegedly frustrating you, blow the whistle, come to the people of Ghana. You remember in 2020, when Akufo-Addo was frustrating Martin Amidu. Amidu came out and said, Akufo-Addo is mother serpent of corruption, the Japadier deal. And you see what we did to Akufo-Addo. You see, he never recovered from that thing. He never. So, Kisi doesn't understand the principle of civic oversight. Citizens have oversight.
I'm curious. When you appeared before him today, what happened? What happened? They asked you to provide the evidence to back your accusation?
Yes. So we couldn't get to that stage because, it's stage by stage. It's a committee. So we raised some legal matters. So
there was a committee that was set up by the OSP himself?
Yes.
Okay, to look into the allegation?
So let's say this. I wonder if we say look into the allegations. They basically want to receive more information from me, which I will do. I'm not running away from. The first one is even there. His own video, I'll play out to him. In his own video, he said that he got the letter, etc. So that's the most important one. The other one's conflict of interest. The conflict of interest allegation I made. That now is before Shraj. So I produced that evidence. The next one is when I said they are corrupt. But that one too. Who produced evidence? Even in the video.
So did you give them that today?
No, we haven't reached there.
Okay, so why didn't you proceed?
So
beyond?
We have to do some housekeeping matters. Before you tell you, procedure is very important. So when you are doing optics, the optics are very important. So the composition of the committee.
But this is interesting. Is there a provision in the OSP's law that allows for this committee to be set up when somebody accuses him or something?
He's not investigating me.
Okay.
That one to be fair. They are not investigating me. Putting it succinctly, they're just saying that give us more information on these matters you've raised. It's very clear. The letter they wrote to me says, I'm not under investigations.
Okay.
It's not that they are going to finish and say, Pebu, you've done wrong. No, that's not it. That's why I said, simply put, Pebu, give us more insights.
But do you need a committee so that you can simply go there and submit a petition or a complaint, if you like, and add all the evidence to it?
So that's another option. So we'll get there.
Okay.
Yeah, so, and I'd already announced that I was going to petition for his removal.
Have you done so?
No, we are still, with hindsight, as we are gathering the petition, you put together all the evidence.
So you're now putting together evidence?
Yes, but
if you're putting together evidence, why do you make explosive allegations against him?
Some of it, the most potent one, he himself brought us the evidence, is the KSM tape. He says he intercepted a letter and went to NIB, allegedly, let me be using because I don't want NIB and the rest to say I'm fewer. Yes, but as I say, NIB, the man says...
So that the earlier point you made, I think that
you've emphasized. That's the most important thing. That's the most, he says...
So there, are you challenging competence?
Yeah.
Is it competence you're going to raise?
Yes, and I actually say collusion. When you've seen the man, of course, competence is easier, but I want to say such obvious gani. You see the man.
That's a serious accusation.
Yes,
you have the evidence to back.
Look, when that fails, you said competence. Competence is so obvious. So if I want to ratchet it up and say it's deliberate, and they say, it's not collusion, but it's incompetent, I'll still win anyway. Okay. They are together. But I want him to feel the moral culpability. You see Ofori-Atta leaving Ghana, and you couldn't blow the whistle. Come on. Evans, look at it. Look at it well.
Okay, well, I mean, we'll see if indeed you are able to discharge that responsibility of backing those claims before the OSP. Just a brief comment on this, because this has to do with Ofori-Atta, and I know you are very well briefed on the matter. The OSP obviously is looking into him and the evidence.
No, they are not looking into me.
They are looking into the claims.
They just are going to receive further information from me. Then they will see what.
They're seeking to receive further information from you to see what it is. Okay.
Yeah, we are all citizens. So,
okay, good.
But except that, as I said, this is not with.
Okay.
Gone like 3 months ago.
Firstly, I would disagree on many fronts with my brother.
Okay.
The OSP cannot investigate himself. The OSP, the SP, that is the special prosecutor, he's the head of the OSP. And so if you have allegations against him, the forum to resolve those allegations certainly will not be the office of the OSP. And tactically it's even not good, because presenting those evidence to him, right, by submitting yourself to him, you are submitting it to his jurisdiction. You are agreeing that he should resolve those matters. What if at the end of the day, he rubbishes every allegation you have made? You wouldn't have gotten justice. But that said, even if you scrutinize what my brother is saying, I don't think that there's sufficient evidence on the basis of what he's saying to remove the special prosecutor, unless you want to do the Tokonu kind of removal, right? Otherwise, there's no basis. I agree with him.
On what point?
On the point that the OSP, there was a misstep in terms of how his... Okay, let me put it this way. In terms of his claim pertaining to the failure to arrest Ken Ofori-Atta, I think there's a serious problem there. As to whether or not that is a sufficient ground for his removal, may require some further interrogation. But why I'm saying that that whole thing supports the claim that I've consistently made that the OSP, in terms of Ken Ofori-Atta's matter, right, there is more to it. And this reinforces.
But what more is there?
There's more, the pursuit, his pursuit of Ken Ofori-Atta suggests some motivation other than, genuine interest in pursuing him for a crime that he has committed. And I'll tell you, firstly, if you recall, when he did his first press conference sometime in March or so, I came out to say, look, why don't you charge this man in absentia if really you have something against him?
He was still gathering evidence, which is now before court.
If you were gathering evidence, when did he charge him?
This week.
This week.
I mean,
when you got to know that the Interpol red alert had been removed.
That's circumstantial. I mean, you can say that it's coincidence.
My brother, if you
and to be fair, when he did a press conference a few weeks back, it was clear that he was going to go to court with the charges, and he gave us a time frame for that.
When was the red alert removed?
Honestly, I don't know. Do you know?
My brother, listen. You see, very respectfully, you know why I will respect people around me? We all went to the same school. Are you getting me? I would never think that I'm more intelligent than you. Never. And so I expect you to think the same way. It is when I do so that I'm likely to fail.
Yeah.
When I respect people's intelligence, I'll be more guided and indeed guarded in my actions and inactions. And I think that is the situation that we are all experiencing in this country. People holding offices sometimes think that they are more intelligent than others. But we went to the same school. I get me. In some instances, there are others who are more intelligent. And even if not more intelligent, perhaps after school, they've acquired substantial experience that we may not have. And so when you are dealing with people, respect them. People referred to his power of arrest. Do you know that the BNI, which is now known as the National Investigative Bureau, doesn't even have the power of arrest? It arrests in collaboration with other agencies of state that have that power.
i.e. police.
I.e. police. And so the OSP is in a special category. It has the power of arrest. When you have the power of arrest, do you go to NIB that doesn't have the power of arrest?
But I made the point to him, what are you going to arrest him for? You can only hold him for 48 hours. He hasn't finished gathering his evidence. So
in my response...
The powers of arrest...
Wait, bear with me, I beg you. I didn't interrupt you. Bear with me. In my response, I will say to you that if nothing at all, let's look at how the other state-owned state agencies, state security agencies, are handling persons of my party stock, NPP.
We've condemned it. It's been condemned.
It's been condemned, right? Nevertheless.
You have, at least.
Yes, it's happening. Is it lawful? It might be an improper exercise of discretion, but not necessarily unlawful. Okay? But it's happening. And so if indeed he wanted Ken and he had a genuine case against him, he would have done that. All that he's trying to do now is to ramp up public sympathy for himself. Ramp up public sympathy for the office of the special prosecutor. That's all he's been trying to do. Press conferences upon press conferences, right? And when you even file the charge, you've read the charge.
Yeah, 78 counts.
Very ridiculous charges.
Why? Causing financial loss to the state?
Well,
Conspiracy to influence
do you know
procurement?
do you know the OSP's mandate?
Corruption-related offences. I guess we summarize it as such.
And corruption-related offences under Act 29. That is the Criminal Offences Act. Corruption and corruption-related offences under any other law, right? And breach of the Public Procurement Act. The fundamental question will be the charges preferred against him will come under that category. We have to interrogate whether or not the facts will even support it. We have to interrogate. I'm saying that as far back as February or March, when he did his first press conference, made everybody to believe that he was bringing Ken down wherever he is, call it Rambo style, and so on and so forth. We came out to say that, look, stop these press conferences, pursue your investigations. If you have anything or basis upon which to charge him, proceed against him. At that time, my brother disagreed with me. We were both on City, Channel 1. And I told him that he can be charged. Ken can be charged in absentia. If really...
No, to be fair, I think I've heard him also make that point.
On that program, he wasn't.
But later...
Yes. You disagreed with me.
Because I've spoken to many times where he's made the point. But he was the first person to make the point.
No, I made that point on City Channel 1 when I was with him.
Then maybe I hadn't heard of Ofori-Atta's issue.
It was on Ofori-Atta's matter. The two of us were...
And to be fair to him, though, I mean, and because he's here, I don't have to speak for him. But I remember that he put in the context of Ofori-Atta saying, I'm available, and you and me saying, send people there and interview him or do a Zoom. But in that particular show, he disagreed with you.
He disagreed with me and even made reference to the number of years he has been at the bar. There was a little...
Well, you were the one who brought
you brought it up.
You said, I said, I'm not much older than you at the bar.
You made reference to the number of years you have been at the bar.
Okay. I mean, but that's okay. That's
we are friends. We are very good friends.
That's past. You're making a substantive point.
Is that, my brother, somebody is playing with all of us, our intelligence. And that is one of the reasons why sometimes, I go or I touch on these matters. Because, look, let's respect everybody. Something really doesn't add up. Something doesn't add up.
But you concede, though, this is due process.
What is due process?
What is happening now? The OSP's work targeting Ken Ofori-Atta is due process.
What part of it is due process?
He has suspicions against him. He investigates. He seeks to arrest him. And anybody else who allegedly conspired with him have been arrested. And he continues to investigate. When he has enough, he's filed the case before court, 78, I'm just coming. And the man because the man is out of the country, he then begins the process to get him to come down. He interacts with him and his lawyers. They gave him a promise. On the date, he didn't show. He says he was not well. He extended it. He removed the notice from his website. And then the next date that he had agreed, it didn't come. I mean, that's due process.
So the exchanges between Ken's lawyers and the OSP, if I fairly recollect, it was in the midst of it that there was a press conference. Was it necessary?
He wasn't updating. In fact, the OSP law mandates him to update the public, to update Ghanaians.
What form?
He can file a report. There are reports by
every 6 months.
Yes.
Annually.
And what form should the report take? Should the form be a press conference, simply convicting the person in the media?
He was just giving us the evidence is gathered so far.
If you've gathered evidence, that's why I said if you've gathered evidence, proceed to court.
He has done so now.
At what point? Between February and now, we have heard, for instance, how he himself has confessed to witnessing Ken leave the country, right? Yet sat down without doing anything.
But that's not accurate. He went to other agencies, the immigration, etc.
So we have
that he has police powers, he should have arrested the
They have
person.
exposed you to the inconsistency in that statement, to the untruthfulness of that statement, being that he himself slept on the job. He slept on the job. He has the power of arrest, but failed to exercise it. Now comes out to blame that on the government of the day, that because Ken is the cousin of the president at the time, that is why he was helpless.
But that's factual. I mean, factual as in he's a cousin. I mean, and obviously at the time, he asked the question, who was the president at the time? You don't expect that the state agencies will cooperate with him.
No. Did he need the cooperation of state agencies? Did he? When you have the power of arrest, when people go to his office, he effects arrest there. He effects arrest when people go to his office. He effects arrest there. So did he need anybody to assist him in the arrest of Ken Ofori-Atta? That is why I'm saying that in the case of Ken Ofori-Atta, there is more to it. When you say that is factual, yes, it's factually correct that Ken is related to the president at the time. But how was the president at the time going to constrain, right, the process of arrest when you have the power of arrest? In any event, during the period, that is December, we all saw security had broken down, little control. But be that as it may, the OSP had the power to arrest. He failed to effect that power, exercise that power. Subsequently, what did he do? Came to organize a press conference and has been ranting.
By which time he now has enough evidence to share with us.
Enough evidence to share with us. Okay.
But not solid enough to go to court. But those things are different. You know that. You lawyers know that.
No.
I mean, what you can update the public on is not the same as what you can put before a court of competence restriction.
I remember you interviewed me on one of the cases. And I remember saying to you that, look, we should even be careful of what we put out. Because at the end of the day, we may have setbacks even in court, for which reason that person may not be convicted. And so we should be careful. In the same token, it is my view, very respectfully, that what we put out by way of update, we have to be careful. I think that it will be sufficient update to say that this is the status of the investigations, right? This is the status of the investigations. We intend to move to court, right, within this period, okay? You don't need to even put out the evidence. What is the use of the evidence to the general public? Okay,
hold on for me. Let me bring Professor Pejutia. Prof, please weigh in quickly for me on Kpebu's appearance before the OSP. What makes the point that he doesn't believe that that forum is right, and that if the OSP wanted further and better particulars about the allegations against his office, that he shouldn't be asking that himself, because he may be a judge in his own course. I mean, where do you stand very briefly on that matter?
Come again, please.
Yeah, can you hear me?
Yes.
So today, Martin Kpebu, who is here with me, was before the OSP. He had made some allegations against the OSP, alleging conflict of interest and possible corruption, and the OSP had invited him to come. He says the invitation was for him to provide further and better particulars. There was a committee that actually has been set up by the OSP. There's a comment by Bafewa that because of the nature of the accusations, the OSP itself should not be the agency receiving further and better particulars. Very brief comment on that for me, if you may.
Yes, I think Bafewa is right, because in that case, he will be acting as a judge in his own court. And number two, I also think that his office is to deal with corruption and corruption-related cases. What Mr. Kpebu has said or is alleged to have said doesn't relate to corruption per se. So if anything at all, he should have referred the matter to another department, probably the police or AGs, to conduct the to interview Mr. Pebu to determine whether he whatever he's saying has some merit in it, but not to his office directly.
And comment on this for me. Is there possibility of contempt of the office that OSP can raise on the matter?
Contempt in what respect?
Contempt of his office, considering the allegations leveled against him and the office. So you're accusing the OSP of corruption and conflict of interest, etc. I mean, if you say the same, say, of a judge, you're definitely in trouble, right? That's along those lines. Is there, within the framework, can the OSP also claim that somebody's in contempt of his office?
I'm not sure I understand the question, actually.
No, I mean, what I mean is, if you take him, right, he's representing a state agency. The OSP is an office that has powers of corruption, prosecution, etc., right?
Exactly.
If you had alleged what Martin had alleged, say, against a judge, right, that will be seen as contempt.
Okay.
The judge can see that as a contempt. Now,
yeah.
Can the OSP see these comments too as contempt of his office, if you may?
Probably so. But frankly, I must say I don't know a lot more of the facts that can help me to make a firm conclusion as to that. But there is that possibility that contempt can come in here.
That's true. That's true. But because this was made publicly, the judge can then say,
I doubt
is contempt.
Very respectfully, I doubt if this is there is anything contemptuous about this. The OSP is not a court.
Yeah,
he's a prosecutor. If you think that Martin has made any allegation against you, which is on top,
there's an office and there's a person, right? That if you make the distinction there, can you be a contempt of the office?
So the OSP's power is circumscribed by law. He cannot go beyond his powers. When you are given a power by a statute, you are circumscribed by the statute. You don't have immunity to breach the statute. And so the OSP's invitation to Martin must fall within the three mandate in terms of investigations and then prosecution.
I asked that question because of your fundamental point, which is a point that he's agreed with. So that if he investigates and he provides a fair and better particulars to him, and he establishes that he was wrong, he didn't have the evidence, then what? Then what?
End of it.
If also, let's flip it, the converse.
He would have defamed him?
The converse.
So what does he do?
First, the converse is also that he investigates him.
It's not investigating.
Wait, no, investigates fair and better particulars, the allegations
you have made available to him, and establishes that there is evidence to it.
Yeah.
What does he do? Is he going to prosecute himself?
Of course not.
Good. Secondly,
but you also haven't answered the other side of that same equation.
Secondly, who is supposed to put a judgment on the set of evidence before him, whether or not it's enough to sustain the allegations that Martin has made against him? He's going to do that. Sabi, we say in Chi, one a ton say Shreni Busuye for, one a discipline be one home. He won't do that. And so that forum, for me, very respectfully to my learned senior and good friend, it's not a good forum.
Also, quickly weighing on the other leg of that same equation before I come to Martin to respond. Which that is, if he investigates and it turns out Martin was wrong, what can he do?
But how is he going to? Do you sincerely think that when he has to investigate a complaint or allegation against himself, he's going to come out and say that Martin is right? So you're saying that. So that's why you're saying that the forum is wrong. So Martin, respond to that for me.
Yes.
The forum is wrong, he says. So why are you before him?
No. So let's put it this way. Like, you can expect that for obvious things like this, I'm alive to them.
Okay.
So I don't want to disclose everything that happened there. So let's just say that we've raised issues. Let's see how.
So you continue to submit yourself to the OSP?
We have raised issues. Yes.
Okay.
We've raised issues. I think I just feel like because I'm not under investigations, just give them some space.
Okay.
Give them some space. And, they're trying to find something. We all want to support the fight. I used to support him a lot, and I'm on record. Say Kisi, say Kisi. I didn't know that Kisi was sleeping on the job.
No,
Okay. Okay. I mean, you've made the point. I want to go to Appiah because he's been on for quite a bit. Let's go to the substantive matter, Professor Appiah. On first of all, today we woke up to the Interpol red notice not being there on the Interpol site. We said today because that's what we got to know about it. But apparently it's been down for a while because the Ken Ofori-Atta had sent in a request for it to be pulled down and had made arguments. The OSP then releases a statement in which it tells us that indeed this has been happening for a few months now and they were required to also respond. They did. Then Ken Ofori-Atta then did a second response to the Interpol, and Interpol has now asked them to do another rebuttal. The deadline for submission of that is 21st of November. So the thing is down now, it's not there. The OSP explained this is just a redaction. So it's not that they've pulled it down, it's just that while they wait to make the decision, they would not show it to the public. Okay, weighing on that for me, you understand international law and how this works. I mean, when you read that, how does that strike you? What's happening here?
Yeah, what the OSP said could be right, because when the Commission to Control Interpol's files receives a petition where somebody is being put on red alert, it acts like a sort of appeals board of a sort with regard to data issues. And so how data protection has become very critical as a human rights issue in recent times. So they have to conduct investigations to determine if really that person should be on the notice or the red notice, red alert or not. And so to ensure that there is some sort of fairness, they can suspend, if I can use that word, the red alert on that person. But it is not, they wouldn't have come to the end of their determination on the matter. So you cannot say categorically that the red alert notice on that person, or in this case, Mr. Ofori-Atta, has been removed, which would then indicate that they decided that not enough evidence has been provided to justify why the red alert should be issued against Mr. Ofori-Atta. So in that respect, I will agree with what the OSP put out. But I must say that there seems to be more information that we don't know of, which probably in the course of the coming days, we may be privy to and will enable us to properly assess the state of affairs and come to a conclusion whether what the OSP is saying or telling us is the truth and the whole truth and nothing but the truth.
And then how does this affect the extradition process? We know that the Attorney General confirms that, and this tussle even played out in the public, right? OSP and the Attorney General, working to the Attorney General, will file the process with the U.S. authorities to have him extradited. Now that this has been taken down, and OSP the Interpol is considering the various arguments to make a decision whether it should still have this red notice up, does that weaken our case at all to have him extradited back home?
In a sense, yes, but not exactly so.
Okay.
Because, when you go through the process of extradition, you have two countries involved. And in between, you have Interpol. Interpol is supposed to help find the alleged criminal and then ensure that the person is arrested and put behind bars for some time while the two countries deal with the legal processes involved. And at the end of the day, it will be up to the country where this person is residing to decide if I want to release a person to be extradited to the other country. And usually that is also regulated by an extradition treaty between the two countries. So the whole process is like going to court. But in this case, you are not going to court in your own country, but going to court in the country where the fugitive is residing. And so you have to go and present your case before a particular court in that country and argue that this person is wanted in Ghana for having allegedly committed this offense and that offense. And to be able to do that successfully, you have to put your files together. You have to get the evidence good together to argue your case. Okay, so when you're able to persuade the court, then the court will then grant the leave for the extradition to take place. Now, looking at the fact that it's only yesterday or so that the OSP came up with the charges against Mr. Ken Ofori-Atta, I think it supports the view or previously the tension that emanated between the Office of the Attorney General and then the OSP. That's some sort of blame game going on, and Attorney General saying that the OSP hasn't done this or that, and OSP also saying this or that. I think it's become clear that at least there was some gaps on the part of the OSP in that charges have not been filed. But the question is also whether it's entirely the job of the ASP to file that, because the two offices will have to work together on that. So I think probably at this stage, having issued the charges against Ken Ofori-Atta and others, probably the file is complete now, but again, you cannot fully tell because we don't have access to all the information available. But if that is the case, then they can then, that is going to do two things. One, it can help in their response to the Ken Ofori-Atta's counsel before the CCF, that's the Commission on the Control of Interpol Files, that it has a case against Ken Ofori-Atta, and this is where it is. And so, and on the other hand, if that issue is cleared on the part of the CCF, then they can then proceed to have him arrested, that is if he's still in the US, and then the matter will proceed to the court for the extradition hearing to be heard. And then if it is determined that he has to be brought to Ghana, then the processes will be initiated to facilitate his extradition to the country.
Fascinating. And Martin, so you followed what has happened today with this Interpol Red Notice. What are your own observations about what has happened and the OSP's explanations as to why it's no longer on the site?
Yeah, so I really think that there isn't much to say about it, because the key thing is that what Prof said, until we get an extradition order, even if you arrest him for 100 years, he's not coming to Ghana. So for me, it's like putting the cat before the horse.
Does it damage the OSP's case in any way?
Oh, obviously, the optics look bad. You see, the OSP was emphasizing the red notice. But you can have a red notice, and even assuming he's grabbed today, before he's brought to Ghana, there must be an extradition order. The judge, so when the U.S. government takes him, they even have to go to court. It's on the say-so of a judge. It's a court order. We do that in Ghana. We represent them all the time.
So what's the point of the red notice then?
Exactly. So it's just to provisionally, that's the word, provisionally arrest him.
Okay, pending the extradition.
Yeah, so we're just getting excited for really nothing. Just provisionally. Well, okay, I know in Ghana, a lot of time when they say somebody's been arrested, there's a lot of excitement. Then very soon the person goes to court and wins the case. You see how we like breaching the 48-hour rule? So maybe he knows that Ghanaians like arrest. You can arrest a person 10 years. If you don't go to court for the merits to be determined, he's not a convict. And so you just be showing the person power. So there isn't much advantage in arresting Ofori-Atta today when you are not yet sure of the extradition itself. It has to be, you go through processes. You see, that's the one they had he and the Attorney General had some differences just about a month ago. So Attorney General is now working on the extradition request. Then they will eventually take it to the U.S., okay? Then the U.S. authorities will look at it, okay? The Home Department, they will look at it. So when they agree, the Secretary of State, they will look at all these things. Then they would apply to their court for the order. So finally, it's going to be a court case. So they will go and argue for and against. So the state will be saying, oh, the Ghanaian authorities need this guy for X, Y, Z reasons. Then Ofori-Atta's lawyers there will say, no. If you bring him to Ghana, he will not get justice, etc. There was one case, extradition I did some years ago with Professor Tefa, just because of even our poor prison conditions. No, the English court didn't bring down the guy. Yeah, we went around to the prisons and did a report. We had to be factual. When they looked at it, among others, so your poor prison conditions, that extradition case, the guy he was not extradited. So it's a long one. So you see why each time this matter comes up, then it's like, Kisi, you watch Ofori-Atta leave. Oh, come on. Yeah. And now see, some people are saying, oh, it's just a small misstep. It's not a small misstep. You know how much money we are spending now? You know what we are losing? The fight against corruption is just dimmed everything, because Ofori-Atta is like he's a crown jewel, the kingpin. So you see when you grab the kingpin.
Allegedly, there's no proof that he is.
Come on.
Yes.
To start with, all these things are hidden problems when you are building a country. Look, we have, as a nation, sometimes we kick ourselves too much in the butt, rightly so. We have high expectations. But we need to also acknowledge that we are young. And so we are building Ghana. That will require less emotions, but more thoughtfulness in terms of our approach in handling things. And I think that we are too emotional with our approach. If we are less emotional, very practical, we can achieve more than we have and meet, our expectations significantly. Why am I saying so? Corruption is a major issue. It must be dealt with. But we need to review how we want it dealt with. For instance, the Office of the Special Prosecutor, I've been on crusade telling people that office needs to be reviewed.
Reviewed?
Yes, I'll come to that. I've said that several
absolutely.
times. I've made that comment several times. I'll tell you why. Since I handled the case of Charles Bisu, I started paying attention to that office. And for me, Ken Ofori-Atta's case is one clear example that office needs to be reviewed. Today, Martin is telling you, and Professor Ejaitua are telling you how Interpol Red Alert operates. Interpol Red Alert is simply a notice to an organization of law enforcement agencies who have agreed to cooperate to fight crime, that we want this person to be arrested. That in and of itself is not an extradition order. It's a provisional arrest. And so you make the application to a task force at the Interpol office, who then review your case to determine the propriety of your request and go ahead to grant it. And so that notice in and of itself, we need to emphasize, is not an extradition request. When you have been arrested, it's provisional. Then a case will have to be made for your extradition. That is a full-blown legal contest. Now here we are, okay? When was this extradition, when was this red alert notice put out? And so assuming Ken had been arrested, okay, and the laws of, let's say, US, where he is, just like the laws of Ghana, has a limit, right, in terms of the duration of time that he can be kept in custody. For which reason, within that period, you must demonstrate a case for his extradition. Had Ken been charged at the time? Had Ken been charged at the time?
Obviously not.
Obviously not. Therefore, even if the red notice had yielded results, Ken would have gone scot-free. It wouldn't have yielded in an extradition. Why? Ken had not been charged you wanted him for investigations. You so desperately thought that you needed him so you could charge him. We pointed out to the OSP that when you look at the Constitution of Ghana, you don't need Ken's presence to charge him. It's a fact. It's a constitutional right, right? And so, really and truly, when you look at how the OSP has handled its office, the record speaks for itself that we are chasing good money with bad money, right? Bad money with good money. I'll give you an example. See, Madam Cecilia Adapa, he will tell you that when you go to the police station right now to make a complaint, a police station has a policeman, no legal training or minimal legal training, can tell you that this case is a civil matter. This case is a criminal matter. And so you expect people with more advanced legal training, an office that receives an investment of the public purse of about an average of 148 million every year, should be in a position to say that this matter is a criminal offense. This matter is within our jurisdiction. But wait, goes on a media rampage, goes to do a search in the woman's house with cameras following a whole Hollywood movie over a period of time.
We didn't get cameras to follow him. That's not exactly.
But we all knew that a search was taking place. A TV3 camera followed him.
No, we all went there because we knew where the woman's house. That's what journalists do.
So you went there?
It wasn't because...
How did you know it was happening?
That's what journalists do.
That's what journalists do?
Yeah, we get information.
Look, so will you follow me to my house?
No, why? You have no person of interest.
Because somebody gives you information.
Yeah, but it's not the OSP.
Exactly. Well, you deny it, but it's the OSP. When I say
it's not the OSP.
To distinguish the SP from the OSP.
Yeah, of course.
It's the OSP. You got the information
OSP.
from the OSP.
No.
Now you went there. After many months of a supposed investigation.
In fact, there are times when people in the MPP will call you because they think that if you are there, you will prevent the OSP from arresting her or taking. So they will call you and say, Mumra. So, it's not the OSP.
Well,
it's not the OSP.
You are saying it.
Yeah, that's what really happened.
I don't expect you to tell
in many of the cases.
I don't expect you to tell me where you intercept your...
I see, because they say MPP, that's why you are running away. I see.
Well, I'm sure...
But that happens.
But I'm sure if you had mentioned NDC, you'd have also run away.
I'm not NDC.
Oh, Martin.
Don't let I don't want to go to the politics. I don't want to go to the partisan politics of it.
See,
but you make a substantive point.
The point is that on many occasions, the OSP should have known, based on the facts of the matter, that this is within my mandate. This is not within my mandate. We have not seen that.
Ken is squarely within his mandate.
Ken is squarely within his mandate. But I've given you a chronology of how the matter has been handled, right? And you see, it is not for nothing that investigative bodies are investigative bodies, but not a court. What they put out is not gospel. I'll give you an example.
But OSP is not just an investigative body. He's a body that prosecutes.
It's a body that prosecutes. He investigates before prosecuting.
True.
And so once you have your facts, you establish that there's a prima facie case, you proceed to prosecute. In the courtroom, the evidence you make available will be tested. Look, I've been in a matter where a confession statement has been rejected by the court, has not been admissible. I've repeated that, look, somebody, an investigator or a prosecutor will think that this case is slam dunk, and so I'm going to win based on that. But when you get to the courtroom, you realize that it's a different ball game, where even admissible evidence may be rejected on public policy grounds. And that is why I have always maintained that some degree of professionalism is required in the manner in which public information or disclosures are handled by way of press conferences. Okay. But when you look at how that office has been handled, okay, it leaves much to be desired. I have said, for instance, on the floor of Parliament, look, why was that office set up? fight corruption and corruption-related offenses. Okay, public procurement breaches. We all know that the cycle of public expenditure starts with the budget. It ends with the public auditor general auditing the expenditure. Then the auditor general puts his report before Parliament, and Parliament Public Accounts Committee investigates it. We know that public expenditure has procurement and so on and so forth. And so if you are very serious in fighting corruption and corruption-related offenses of public office holders, politically exposed persons, breaches of the Public Procurement Act, then the Public Accounts Committee's findings should be the Bible, the gospel, it should be the reading material of the OSP.
Yeah, and just on that point, and that's why the 78 charges are littered with procurement breaches. It's also part of that. But I want to take a break. When I return, I'll hear from Professor Appiah on, so what 78 charges, where do we go from here? Consider this is now going to go before court. And should Ken Ofori-Atta, now that the charges have been filed, simply then decide to come and face them? That's one of the things that his lawyers have said, that there are no charges. Now they've been filed. Would he advise, if he was his lawyer, to come now, face the charges, clear his name? Martin Kpebu willing to. I've already seen Buffalo while shaking his head. He may not advise him to, but let's get your thoughts after this. Still have you on PM Express. Professor Appiah, you have Martin Kpebu and Buffalo all joining me on the conversation that has dominated the headlines since the OSP filed 78 charges against the former finance minister and 8 others, I believe. And just wrapping up, Professor Appiah, so the charges have been filed. Would you, if you were advising Ken Ofori-Atta, to simply turn himself in, come to Ghana, defend himself and clear his name?
Well, so now at this stage, it looks like the OSP may be turning to Plan B, which is trying to try Mr. Ken Ofori-Atta in absentia. And that raises its own legal issues and human rights concerns. So I think, among others, of course, if it's trial in absentia, then it means that the person is not physically present in the country to face trial. And so that means that it's going to raise the issue about fair trial, because the person should have been in the court to answer the charges and to be able to do cross-examination and so on. But that has not been possible. And so in that respect, you need to ask rather first the OSP whether that, in what sense, of course, the Constitution allows that. But in that case, would he be able to make a case that will really justify any conclusions of the courts in this respect? And so, in my opinion, I think that the trial in absentia strategy might work if the Plan A doesn't work, but maybe his attention is more on the Plan A. And so to advise Ken Ofori-Atta, I would think that, of course, the best thing is for him to come and face the law and go to court, because so far he hasn't indicated that he doesn't want to, he doesn't have a case to answer, but he is relying on the fact that he's not been well. So for the best way to resolve the issue is actually to have him in court in person. And so otherwise, if he stays away, judgment is still going to go against him. But at least there's one issue also with the trial in absentia, which is when, for example, if he's sentenced to jail, when does this jail term begin to run? Because the courts have decided that sentencing begins immediately after trial. So if the person is not there, does the sentencing begin to run? And if he doesn't show up to be imprisoned, and the time passes, maybe it's 10 years, and 10 years pass before he returns to the country, would we say that the sentence has run its course, therefore he should go scot-free? And so that is some of the conundrums that go with the trial in absentia. So in some countries, actually what they do is that they of course, trial in absentia should be used as a last resort. But in some countries, they say that, okay, there is a possibility of retrial if the person resurfaces in the country, or we can give that person legal representation so that even in his absence, the lawyers, there will be a lawyer for him.
And in the case of Ken, he has lawyers. They've been speaking for him in the last few weeks.
Yeah, so in that case, yes, then that will be a way of minimizing the likelihood of fair trial issues coming into effect his right to have a fair day in court. So at the end of the day, if plan A doesn't work, then I think there's no other choice than to go for the trial in absentia, in spite of its weaknesses. But I think to be guided by human rights principles and procedures, it may work out.
Yeah, and whilst we talk about that, the Attorney General has disclosed that they filed an extradition request for the return of Sedina Tamaklo, who was also convicted in absentia. So that is an interesting disclosure. But for just a minute to wrap up, I just give you a minute there. Would you advise him to return?
Article 19(3) of the 1992 Constitution reads as follows: the trial of a person charged with a criminal offense shall take place in his presence unless A, he refuses to appear before the court for the trial to be conducted in his presence after he has been duly notified of the trial. And so he can be tried in absentia. The OSP, if he thinks that he's on firm grounds, can proceed to to prosecute Ken Ofori-Atta. If he thinks he's on firm grounds, he can.
That's what he's doing now. He's filed the charges. Obviously, he's prosecuting him
My brother,
in his absence.
I've looked at the charges. You obviously don't have time.
Yeah.
And
I don't want to litigate it because it's going to go to court. So
exactly.
court of competent jurisdiction will deal with it.
They are laughable, to say the least. Very laughable.
Yeah, I mean, it's okay. I mean, that's your verdict on it. The court will decide. But
there are two serious issues there. You see, the trial in absentia, the reason we need to get on with it is that if you don't do that, you don't have a chance to be able to freeze his assets.
But he can do that now, can't he not? Now that he filed the charges.
Exactly. So you need to have a case in court to be able to freeze the assets. Otherwise, you see, if they sought to freeze the assets...
But he froze the assets of Sisley Adapa without charges before court.
Yes, you have when you do it, you have 2 weeks. Within 2 weeks, that's latest by the 14th day, you should be in court to get a judge's order. So if we don't do a trial, you cannot freeze the asset. Effectively means that every 2 weeks, then he'll be renewing. People will say it's an abuse. That's not the law. So he needs to be in court. And I beg to differ. To be honest, I don't place much premium on Ofori-Atta going to jail. I'm more interested in recovering the money. I don't place much premium. If he gets wears the badge of a convict, a felon, that you're a convicted felon, for me it's sufficient. Then get the money, follow the money, get the money. We need the money for more important things than just throwing people into jail.
Okay.
So let's get on with it so that we can get his assets frozen, and then hopefully when we win, we can confiscate his assets.
Well, those accused will have their day in court. Whether or not Ken will do too, whether he'll return or not, nobody knows. The OSP and the Attorney General's Department, they are working on extraditing him back. We'll see. Good rest of your evening.